water law yet. Okay, apart, we have the Water Act 1974 that deals with water pollution, but first of all, 1974 is still very early in terms of environmental law development. And secondly, that has had no impact, again, on all the other water laws. Irrigation acts have not been influenced, per se, by the Water Act 1974. They exist in parallel, but there's been very little, if any, cross-fertilization. So now we have a whole body of environmental law and environmental law principles. For instance, the precautionary principle, which is very relevant in water law. These principles have no existence and no visibility in existing water law, and the new water laws that have been adopted through water sector reforms don't do anything to promote and foster that agenda. So that, again, is something that needs to be addressed, because we have water law that develops in a certain direction, environmental law in a different direction, and while we are saying that the environment is key to both, in fact that's not the case, at least not in legal terms. Another basic point that I guess, at least that's something that we definitely need to discuss, I suppose, in this context and in this group, is the fact that the government, and I put it at all levels, basically that means from the panchayat level to the union government, will necessarily always have a central role to play in the water sector. Two reasons I've highlighted here, I'm sure there would be many more. One is the fact that the responsibility for the implementation and the realization of the human right to water, and human rights generally, cannot be abdicated or delegated to other actors. The buck comes back to the government always. That doesn't mean that certain functions can be delegated, that certain functions cannot be delegated to other actors, but the primary responsibility has to always lay with the government. And depending on the kind of reforms that are being introduced, it's not always clear that the government really still is in control of what happens. Secondly, and that, for instance, applies to the issue of setting up regulatory authorities based on the model of electricity, even though water is completely different. The nature of water as a substance that brings life, human life, and life in general, makes it by definition something that in law cannot be regulated like other substances. I put substance here on purpose because as soon as we say natural resource, we immediately again in that context of economic exploitation of resources. Oil and gas and minerals are natural resources. And fine, if generally they are there to be exploited for economic development purposes, that's one thing. Water has to be considered differently because its nature is fundamentally different. The legal framework hasn't recognized that, and that's true both at the national and international level. That's not a specificity here. Finally, there's the issue of decentralization. Decentralization has been key to water sector reforms. It's also key in terms of constitutional development. The issue here is that decentralization has to happen as per the frameworks that's been set in the Constitution, so the 73rd and 74th Amendments. And one of the big problems we have to deal with here is the fact that user groups, the so-called user groups, for instance, water user associations, are set up beside the constitutional framework and, in a sense, displace the existing power structures that's been set up, because panchayats have been given powers over water resources at the local level. And in that sense, water user associations displace or take away the power that the panchayat in principle have. So here we have a problem of putting one bottle into the other bottle because, okay, just to give one example, because water user associations have no reservation framework apart from one exception, which is Chhattisgarh. And so there is neither gender reservation nor SC/ST reservation, something that would be imposed and that would be a matter of course in the Panchayati Raj framework. Okay, just in terms of where is it that we can go forward in very, very general terms, because that was the way we are at the beginning of the process. I guess the way in which the role of law in water conflicts has to be taken forward is by going back, first of all, to the constitutional framework that we have. one of the issues that we have to deal with is that the water law reforms that have been brought into the country over the past 10 years are the brainchild of water sector reforms, and these water sector reforms that we know clearly are the same policy consensus that we find at the international level. Whether it's been mostly developed at the international level or mostly adopted here, that's beside the point. The fact is that it's an international policy consensus that's not necessarily adapted to the needs of the country, and that definitely has nothing to do with the organic development of water law in the country. So in a sense, water law has developed in one way, the constitution as well as the international legal framework, whether the environment, human rights framework, has developed in parallel, and the two have not been matched. So there is a need to ensure that water law matches up to the basic principles, whether it is fundamental rights, whether it is the non-discrimination provision in the Constitution or other principles. Similarly, again, going back to the Supreme Court contribution to the development of water law, we need to make sure that that principle of public trust, which is very significant and which is probably the only way to move beyond that the colonial mindset of the state owns the water, has to be, something has to be done with it, and we have to go back to these principles. Finally, one of the major challenges, going back to one of the things I said at the beginning, is the sectoral nature of water law ensures that there is significant scope for conflicts between the different sectors. As long as we have different laws for irrigation, for groundwater, there is no doubt, and especially since they are developed in parallel rather than jointly, there is no doubt that there will always be significant scope for conflict, both in practice and in legal terms, because there are no general principles that are developed that would apply to all these laws, apart from the, again, yes, we have the principle of public trust, but unless you go back to a High Court or Supreme Court to have it tested against what's happening in practice, you won't actually get the substance of that principle being applied. So it's not quite enough. So we have different acts that are not gelled together by principles. And also we have different acts that propose different measures. Again, groundwater acts tend to promote centralization and control in the hands of the government, whereas the new water user association legislation for irrigation tend to promote the taking away of the power from the government in favor of management by user groups. The two are completely different. They may be reconciled, but the existing legal framework doesn't actually give you the framework for doing so, because it's all been developed in a piecemeal manner without having in mind the broader needs of the water sector per se. Thank you very much.